Good day, Crime Talk aficionados. This is Crime Talk. We have a great show for you today. First, Bryan Kohberber wants the hearing and their briefs regarding the investigative genetic genealogy unsealed for the public to see. I wonder what's changed. Daniel Penny is back riding the subway. New Yorkers can rest easy. The subways are safe again. Don't shoot a police dog. That's all I got to say about that. I am so glad my kids are grown adults, but I'm not sure I want my grandkids to go to public schools after you hear about this custodian. Kouri Richins, she's going to create some new law in Utah. And why do punks always pick on little old ladies? I know, that's a rhetorical question. Because they're punks. And we have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. And hit that bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps. Now, before we get to the docket, go to crimetalksearch.com. Sign up for that background subscription service today. If somebody has a criminal history, if somebody has 20 different emails that maybe you're getting involved with, you may want to know that. Why are those there for? Why does he have all those emails? Is it because they're all different emails for the dating apps that he has or his OnlyFans pages that he follows? You may want to check it out. I'm telling you, go to crimetalksearch.com. You're going to find out if somebody has that criminal history. Are they on a registry? Are they married? Are they divorced? Those little things you may want to know before somebody new comes into your life. So go to crimetalksearch.com. You're going to be happy you did. Let's go ahead and open the record for January 16th of 2025. First on the record, Bryan Kohberber. Remember everything about the Bryan Kohberber case? The defense kept saying, secret, secret, secret. Everything needs to be sealed. It's going to affect Mr. Kohberger's right to a fair trial. We heard all that nonsense in the Lori Vallow case. We heard that all that nonsense in the Chad Daybell case in Idaho. And they've got some weird rules in Idaho where everything gets sealed, right? The motions get sealed because it's too sensitive for everybody to see. And I got a real problem with that. It's public records. It's public information. That's what happens when you're involved in litigation. Things get out there maybe you don't want to see. It's just the way things are. We live in an open society. But for the longest time, the Kohberger defense team has wanted everything sealed. We're protecting his right to a fair trial. Oh my goodness, oh my goodness, oh my goodness, right? And I said, let's see it. Let's see what it is. Well, anyway, the court has set a motions hearing in the Bryan Kohberger matter for January 21st at 10 a.m. Mountain Time. And it's going to be a closed, sealed hearing by remote video means to hear the defense motion to unseal materials related to its request to suppress evidence stemming from the use of investigative genetic genealogy, DNA, and to consider what portions, if any, and under what circumstances should the various motions set to be heard on January 23rd and January 24th be open to the public or available via live video. The clerk will provide that video link, etc., etc., etc. So, of course, inquiring minds want to know. So let's go to the motion. And it is rather straightforward. Comes now, Bryan Kohberger, by and through his attorneys of record, and hereby moves this honorable court for an order to unseal the investigative genetic genealogy, also referred to as IGG, suppression, briefing, and related hearing. Now, in the footnote, it says the related briefs are the memorandum in support for motion to suppress regarding genetic information with attached exhibits filed under seal on November 18th of 2024, sealed objection to defendant's motion to suppress genetic information and attached exhibits filed under seal on December 6th of 2024, and 3, a reply to the state's objection to defendant's motion to suppress in support of genetic information with attached exhibits filed under seal on December 20th of 2024. Goes through the procedural history. Mr. Kohberger filed his motion to compel IGG discovery on June 22nd of 2023. Those motions were filed on June 22nd, 2023 and April 15th of 2024. The hearing on that matter was public and involved the testimony of several expert witnesses. The court ordered the production of records in camera and under seal. Mr. Kohberger filed a second motion to compel the IGG discovery on April 15th of 2024. And over the objection of Mr. Kohberger, the court required that the portion of the May 30th, 2024 hearing on the second motion to compel IGG discovery be closed. The court again ordered the production of records under seal. The court's concern were the privacy rights of the names of individuals identified in Mr. Kohberger's family tree. At the first and second motion to compel the IGG discovery, Mr. Kohberger argued that he would be filing a motion to suppress the IGG. He asked the court to allow the pleading and hearing be public. On May 20th, 2024, the court indicated it would take the matter up after the suppression pleadings were filed. In the interim, venue changed, and this case is now before a new judge. The motion to suppress regarding genetic information was filed on November 14th of 2024 and now fully briefed. Pursuant to court discretion, the parties stipulated to file all IGG suppression pleadings under seal. No names of the extended family members are discussed in the briefing. The matter is set for hearing on January 23rd and 24th, and Mr. Kohberger requests that the briefings be unsealed and the hearing take place in open court. Now, due to national and international attention to this case and in the interest of protecting Mr. Kohberger's right to a fair trial, many pleadings in this case have been sealed appropriately pursuant to the Administrative Rule 32. Mr. Kohberger has a right to a public trial, and sealing a suppression hearing is a clear violation of his right to a public trial. In addition to Mr. Kohberger's right to a public trial, the public has a First Amendment right to know what goes on in court. And they cite a case in the Idaho Code section recognizes that records contained in court files of judicial proceedings may be exempt from disclosure under rules promulgated by the Idaho Supreme Court. And the Idaho Supreme Court adopted the Idaho Court of Administrative Rule 32 to define when public access to judicial records may be denied. And when the court is considering whether to seal the record, Rule 32I directs the court to consider the traditional legal concepts in the law of the right to a fair trial, invasion of privacy, defamation, and invasion of proprietary business records, as well as common sense respect for shielding highly intimate materials about persons. Records may be sealed or redacted if the court determines and makes a finding of fact as to whether the interest in privacy or public disclosure predominates. The court's decision to seal judicial records is discretionary. Here, the way in which the IGG material was accessed and used in a matter warranting public disclosure and should not be shielded from the public's right to know. This matter is of utmost importance to Mr. Kohberger's right to a public hearing. Holding the hearing in open court will not prejudice the parties and should be held in open court. The issue raised are legal issues, and cases with similar issues are being decided in other states. The issues raised in Mr. Kohberger's suppression motions are those that were discussed in the public hearing on the first motion to compel. Additionally, the way in which the IGG occurred in this case has been made public in other cases. Mr. Kohberger has the right to public trial, and a public has a right to know how the genetic information was used in this case. Neither the state nor Mr. Kohberger will be prejudiced by the unsealing the briefings and holding the IGG hearing in open court. So there you go, ladies and gentlemen. Like I said, Kohberger's defense is secret. But this issue, they want it out there. Now, I think it should be out there. Now, my guess is that there is something completely offensive that is going to shock the conscience as it relates to how this investigative genetic genealogy information was obtained and used, and you all are going to be offended. And finally, I guess Bryan Kohberger's defense team is trying to say, hey, we need to try to win something here in the court of public opinion, and maybe something wasn't done fairly, and maybe something was done just a little sketchy, so to speak, how they got to the DNA. Remember, the prosecution has said, yeah, sure, we used this IGG. We used it to develop a profile. We developed a hit. But then we went back and got an order from the court to grant us to get the ability to get the DNA from Bryan Kohberger, to compare that to the DNA that was on the K-bar sheath right here, because we're the only channel that has a K-bar when we talk about Bryan Kohberger case. Yes, Mine goes back to 1988 when I enlisted in the Marine Corps and still have it. Who would have known I would have had to go to the garage, go to an old sea bag, and dig out my K-bar just to give you all an example of why it's alleged that Mr. Kohberger's DNA was on that little button right there. And then they use the IgG DNA to create that profile, to create a suspect, to then start working backwards towards Bryan Kohberber. Yes, the defense has always said they want everything, just about everything, sealed in the Bryan Kohberger matter. And now they want this out to the public because they see some advantage to it. It must be offensive to the public. It must be shocking. I've said this before, and I will say this again, ladies and gentlemen. I don't know if Bryan Kohberger did it. Sure, he's got some explaining to do while that DNA is there underneath the body on a knife sheath. Got some explaining to do. And I understand he doesn't have to explain it away. He has the presumption of innocence and the right to remain silent. But somebody's got to explain how it got there. Not to me, but to a jury. But there must be something done there, and the jury wants to know. But I've said this before, and I'll say it again. If you show the jury an injustice, they will correct it. They will find somebody not guilty if they believe they're getting railroaded. The jury will correct an injustice if they believe that somebody has been treated completely unfairly. So yes, ladies and gentlemen, it's going to be interesting next week to watch, and it's going to be even more interesting to see if the judge allows it. And what is the position on or for the prosecution? My guess is they want to keep it quiet. My guess is this makes the prosecution and the government and the FBI that engaged in this genealogical DNA query that they created, it's going to make them look bad. That's why the defense wants it out there. I just wish the defense had been a little more consistent, saying they want everything out there in the public eye. Yes, Bryan Kohberger has a right to know, and yes, the public has yes, Bryan Kohberger has a right to a public trial, and yes, the public has a right to know. Obviously, there's some very intimate details of things. We're not going to get somebody's taxes or social security numbers. I get that. But everything else we should have a right to see if it's in a pleading. I just wish they'd been a little more consistent with it. Maybe I wouldn't be so skeptical of their reasoning this particular time when they want it disclosed to the public. Clearly, they're doing their jobs. They're saying, hey, we think this is going to benefit us, so let's get it out there and embarrass the prosecution. Just the way it works in litigation, ladies and gentlemen. Next on the docket, Daniel Penny rides again. That's right, Daniel Penny was spotted riding on a New York subway just a month after he was acquitted of the chokehold death of a homeless man, a guy by the name of Jordan Neely. Now, Mr. Penny was photographed by a bystander appearing quite relaxed and reading a book on the subway, and it obviously went somewhat viral on social media. Now, Penny's acquittal did upset some people in New York. I can't imagine who, really. But a lot of people branded him a hero, like I did, for his actions back in May of 2023 when he put Mr. Neely, a schizophrenic former Michael Jackson impersonator, in a headlock when he got on the train saying that he was going to kill somebody and he knew he was going to go to prison and he didn't care. Mr. Penny, the only one with any intestinal fortitude whatsoever, confronted the man, put him in a chokehold. Mr. Neely ultimately died, but Mr. Penny was found not guilty. The jury determined that he did nothing unreasonable and that the chokehold was not illegal that he placed Mr. Neely in. So anyway, it's safe to ride the subways again. Well, probably not, but at least Daniel Penny has the guts to do it again. Hats off to Daniel Penny. That man is a hero. Next, don't kill a police dog. That's right. So before this guy, Sean Christopher Davis, was killed in a shootout with police on Wednesday evening, he shot and wounded a canine dog belonging to the United States Marshal Service. That's right. The canine that has been named Rocky alerted officers after finding Mr. Davis hiding in a trash bin behind the same Southwest Houston strip center where Davis gunned down a deputy sheriff, Jesus Vargas, hours earlier. Now, when Rocky jumped into the dumpster, Davis shot the canine twice before he was ultimately shot and killed by police officers as well. Now, the interesting aspect here that people have to understand, according to the U.S. Marshals, was that this canine saved lives. So when that canine went in there, he decided to take the dog out. The marshals said that that proved that the canine basically saved the officers' lives around him. Now, in the middle of the chaos, law enforcement officers carried the injured canine to a helicopter so that he could be rushed to a veterinary hospital for treatment. Now, the Houston Police Department said the dog was stable, resting, and expected to survive. Rocky's handler stayed with him overnight and will remain by his side until he is discharged. Don't hurt a dog. I mean, seriously. And let alone, if you hurt a canine dog, police dog, it's like shooting a cop. It really is. And that individual that shot him, he's lucky. He's lucky, I guess, that it ended for him in a dumpster. Next, like I said in opening, I'm glad my kids are grown, but I'm not sure I'd send them to public school after you take a listen to this story. So a former Cumberland County, and this is in New Jersey, elementary school janitor accused of contaminating cafeteria food back in 2023 has pled guilty. So Giovanni Imperzeri worked as a janitor since 2019 for the Elizabeth Moore School in the Upper Deerfield School District. Prosecutors alleged he contaminated food products and utensils in the school cafeteria with his saliva, urine, and feces. Now, the food items were intended for consumption by students and staff. And in one incident, police say old Giovanni sprayed bleach into the container of cucumbers with the intent of harming children. In another incident, police say that old Giovanni touched his private areas with bread, spit on it, and then put the bread back into the container to be served to students. He also allegedly subjected various cooking utensils and other objects from the school to his private parts. And old Giovanni, guess what? He was arrested back in October of 2023 after videos were posted on social media. That's right. In a social media chat room, old Giovanni allegedly wrote that he did these sorts of things as a sexual fetish. He also allegedly said he was doing the devil's work. Now, during the investigation, police say that old Giovanni was found to be in possession of child pornography. Oh, shocking. And he just happened to work with children. I wonder if there's any direct connection to that. I don't know. Once again, how many times have we said it? We'll say it again. Be careful of the people working around your children, okay? I love my kids. Do I want to go hang out with other people's small children? No, I don't. No. I'm sure their kids are lovely, but I want nothing to do with them, okay? Be careful of people that want to hang out with your kids, ladies and gentlemen. Really. Anyway, so Giovanni pled guilty, third-degree possession of child sexual abuse material, and he's scheduled to be sentenced on March 28th. Now, the official misconduct charge carries a recommended sentence of 5 years in the New Jersey State Penitentiary, and the child porn possession carries 3 years. Both sentences are to run consecutively, which means one after another. Gosh, can I think of a greater spot there to talk about CrimeTalkSearch.com? Who is around your children, ladies and gentlemen? Check them out. How many times have I got to say this? I have represented a lot of teachers over the years, ladies and gentlemen, right? Like I said, in my other than the law and work, what do I like to do? I like aviation. Where are you going to find me hanging out? Looking at planes, not hanging out at the local schoolyard, helping out the little kiddies. Not going to find that. Next on the docket, Kouri Richins. Her case is going to make some new legal ground there in Utah. That's right. Kouri Richins' trial could become the first case in the state to pool prospective jurors from 2 counties. Now, if the state's highest court agrees with the Summit County prosecutors and her defense attorneys. Now, the Utah Supreme Court announced on January 6th that it would make a ruling on whether prospective jurors would be drawn from Salt Lake City and if voir dire can be conducted in person rather than online. A date for the expedited briefing has not been announced, but the appellate group representing the Summit County Attorney's Office and defense asked for a decision to be made by February. Now, lawyers for both sides filed joint petitions last month asking the court to overturn a ruling made by the presiding judge who said that they failed to show that there was extraordinary circumstances in this case that would allow for these special rules. The judge approved the request to hold jury selection in person and was willing to expand the pool beyond Summit County residents. However, he said he was unfamiliar with any other cases in Utah that have pooled jurors from 2 counties. We'll have to wait and see. Anyway, defense attorneys argued for the need of diversity of the prospective jury pool, and the county attorneys agreed. The judge also supported the appeal, but said the 2 sides may be swimming upstream on that one. Because of the challenging of clearing a court calendar for 4 weeks, and because Kouri Richins has been incarcerated for 18 months, the parties do not want to move the trial. So a joint motion for expedited review stated that the parties are concerned about their ability to impanel an impartial jury in a timely manner now that they are not allowed to hold in-person voir dire or to expand the veneer of the Salt Lake City County jurors. The Utah Supreme Court ruling will determine how jury selection is conducted and if it will be expanded to Salt Lake County. Defense attorneys also filed a motion with the 3rd District Court earlier this month seeking to exclude evidence from the murder trial set to last 4 weeks starting in April. Now, Kouri's legal counsel asked the judge to suppress the 6-page walk the dog letter, which was found within the manila envelope in Richins' Summit County jail cell. Now, prosecutors previously believed the other material inside could be relevant after the discovery of the walk the dog letter, which they said was a request from Kouri to her mother to ask her brother to provide false testimony. Kouri's defense claims the writing was an excerpt from a fictional mystery book she authored about drugs and Mexican prisons. Anyway, the judge ruled in February Kouri can keep the 33-page manuscript from prosecutors, but that she must turn over a letter written to her from another inmate. That latest motion would determine whether the 6-page walk the dog letter is considered privilege. The defense also wants the judge to suppress all electronic data obtained from Kouri's cell phone, arguing the search warrants were improperly issued and overly broad. And a 3rd motion requested statements and other physical evidence from before Kouri's arrest be limited from trial as well. A pretrial hearing is set for January 23rd to determine the admissibility of that evidence. Now, Kouri faces 9 felony charges stemming from the death of her husband, Eric Richins, including aggravated murder and attempted criminal homicide. And Eric died of fentanyl overdose back in March of 2022, and prosecutors allege that Kouri poisoned him with a Moscow Mule cocktail laced with fentanyl, and that she attempted to do it months earlier with a drug-laced sandwich on Valentine's Day. The attorneys for the prosecution said that Kouri felt trapped in her marriage and had a financial motive to kill her husband. Kouri Richins and her family have maintained her innocence. Next on the docket, why do punks always pick on little old ladies? Well, it's a rhetorical question. Because they're punks. That's right. Take a look at this. Florida police are searching for a man seen on camera robbing an elderly woman in an attack outside of an Orlando convenience store on Wednesday. The Orange County Sheriff's Office said the violent robbery took place outside a store on Curry Ford Road near the intersection of South Goldenrod Road on Wednesday morning. The security footage shared by the Sheriff's Office shows the 83-year-old, who was not named, can be seen walking out of the store attempting to get into her car with lottery winnings in her hand. At the time, the suspects, believed to be Diego Stalin Tavares Fleury, starts walking towards the woman from the sidewalk area behind her. He approaches her and tries to swipe the winnings out of her hand. Then some sort of verbal altercation takes place. Another man walks out of the store and appears to tell Fleury to leave. Fleury then goes after the woman and starts trying to take the money while the other man tries to pull him off the victim. Fleury drags the woman in the parking lot as she holds on to her winnings and ultimately steals the money from her. The other man appears to try and get the money back for the woman, but Fleury shoves him and takes off running. As of Wednesday evening, he has not been located. They've issued a warrant for Mr. Fleury on charges of robbery, suddenly snatching this woman's money from her, and battery as well. If anybody has any information, they can contact a crime line at 800-423-8477. Next, this day in legal history. On January 16th, 1920, the 18th Amendment to the United States Constitution came into effect and is scheduled 1 year after ratification, marking the beginning of Prohibition. That's right, ladies and gentlemen, no alcohol. Could you imagine a world without it? It'd probably be a little nicer place, just saying. No, I'm no teetotaler, don't get me wrong. I've made a good living of people that have had alcohol issues because they cannot control it. It creates a lot of issues, ladies and gentlemen. Like I said, I'm no teetotaler, but drink responsibly. Next, on January 16th, 1581, the English Parliament banned Roman Catholicism throughout the country during the reign of Queen Elizabeth I. And from that time on, Catholicism declined in England until the Catholic emancipation in the late 18th century. And on this day, on January 16th, 1979, the execution of Ted Bundy was postponed. That's right, the serial killer Ted Bundy's scheduled execution in Florida was postponed due to legal appeals. And on this date in 1991, the United States Supreme Court ruled on the issue of cruel and unusual punishment. In a case out of Michigan, the United States Supreme Court upheld a sentence of life without parole for a first-time drug offense, ruling it did not constitute cruel and unusual punishment. Now, this decision influenced sentencing laws and the interpretation of the Eighth Amendment concerning proportionality in non-capital offenses. Not sure that would hold up today, and that's why you ask for a proportionality review to say, is this really fair to send a first-time person to life with prison for a drug offense? Okay, for murder, but not so much for a drug offense. And anyway, on this date, on January 16th, 1984, the United States Supreme Court made a decision on child pornography. That's right. In New York versus Ferber, the Supreme Court ruled that the First Amendment does not protect the distribution of child pornography. Obviously, it was a landmark decision, and it allowed states to prohibit the sale and distribution of materials depicting sexual performances by minors, strengthening child protection laws. And finally, our dumb criminal of the day. Anybody that flies, anybody that's a pilot knows the first thing you learn, 8 hours from bottle to throttle. So 8 hours from the time you put that last drink down until you fly again. And this Southwest pilot just ruined his entire career. Now, my guess is he may have an alcohol problem. He's given the presumption of innocence like everybody, but he is our dumb criminal of the day. So like I said, a Southwest Airlines pilot was arrested moments before he was due to take off, and he was accused of being drunk. Now, Mr. David Alsop was apprehended at the Savannah Hilton Head International Airport, an airport that I am quite familiar with, a small airport indeed. Anyway, the police were called to report that he had shown up to work intoxicated, and the police took him in custody about 7 a.m. Now, Alsop, who's from New Hampshire, was due to be the captain of a flight to Chicago. Needless to say, that didn't take place, at least not on time, because the captain was arrested in front of all of the passengers. Customers on board the flight were delayed nearly 4 hours, but they eventually got to their destination. Now, several passengers were accommodated on different flights, and they obviously tried to ease the disruption. Needless to say, Mr. Alsop has been removed from service pending investigation by the airline and the police. It shows on Mr. Alsop's LinkedIn that he has been a pilot with Southwest for 19 years. Prior to that, he was a pilot in the Air Force. Police are yet to state how they were alerted to the fact that Mr. Alsop may have been too drunk to fly. Mr. Alsop, ruined your very lucrative, good career of being an airline pilot. I hope you get help if you got a drinking problem. If you don't have a drinking problem, boy, that was dumb. Anyway, that's all we have for you today, ladies and gentlemen. Thanks for watching. We'll see you next time on Crime Talk. And remember, yes, the Constitution matters.